Hello stranger, it's been a minute since we last kicked it. And by the way, just got in town, and I won't let cumulus clouds all in the sky ruin my vibe. Usually I don't do this often, but since recruiting isn't an option, use you unusual rain and thunder. Baby, I wonder, would you just put your sweats on for me? Yeah. I got the plug, I made the call for me. I'm talking late night for you. Let me lay a great time on you. Don't hesitate, no, don't you? Just say you will. Come through and chill. Just say you will. Come through and chill. I wanna all night. Say it. I wanna all night. I wanna all night. Say it. I wanna all night. Hello stranger, babe's been waiting. Just as I recall that ass is still amazing. Playing baby, saying baby, love it shit, you know I'm crazy. So go ahead and put a drink up. I'm so glad we got to link up. Yeah, it's taking that off of me. Yeah. I got the plug, I made the call for me. I'm talking late night for you. Let me lay a great time on you. Don't make me wait, no, don't you? Just say you will. Come through and chill. 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 I wanna all night. Say it. I wanna all night. I wanna all night. Say it. I wanna all night. Pick up the phone, show me it was real. Pick up the phone, show me it was real. Pick up the phone, show me it was real. Pick up the phone.
Claps. Do not give me. Oh my gosh. Say hi to them. Me and you been seeing each other all day, all GD day. Tell them how you missed your hair appointment. I wanted to miss that motherfucker. Cookie, watch your mouth. You gotta stay flat. And you already got green, so what you gonna get for St. Patrick's Day? I'm not getting shit for St. Patrick's Day. I don't drink. Okay. Very tempting. Get over there. Ciao. Hey y'all. Hey y'all. Not do cookie. Hey y'all, moms. Hey sweet asses. Hey DMV sister. I want to get with y'all. Hey sir, will go off. Hello sir, will go off. You look so cute on your picture. Where did you take that? The dude had family day? Oh, okay. Cool. Hey, welcome to Brett's Block. Hey, needy love. Hey, is that Catch 2? Catch 2? Hey. Hey, Polly. How you doing? Hey, Peggy. Hey, Miss Easter. Hey, Miss Gail at night, child. Miss Gail been all up in the other sectors, okay? Let me tell y'all. Y'all know I've been all watching this Anton Daniels mess. Miss Gail, I got a video coming out at 8 o'clock. Make sure you watch it. Make sure you watch it and tell me what you think about my thoughts on it. I got some more coming. I'm going to do some more reaction videos to some of the stuff that's already out. But that's why I've been focused on watching that bullshit. Period. Hey, Miss Bridget J. It's me. Hello. Hey, Miss Gloria Lacey. Hey, Astute. Hey, just a Jersey growl trying to be more. Period. Hey, Miss Victoria. Hey, Lucky Charm. Hey, PB Easy in the mofo easy. Period. Hey, Miss Bernadette. Hey, Miss Mary. Child, Miss Mary, you is one day away from the B-Day. What you doing? Send me an email, Miss Mary, if you ain't got no cash out. Send me an email. All right. I gotta get my Miss Mary soul for her birthday. And that's on period. Don't none of y'all be jealous if I don't get shown up for y'all birthday. Well, we missed Miss Mary's birthday last year. Remember? When the channel had got terminated and it was mayhem all around YouTube. Child. Yes. Hey, Miss Gwen, how you been? Hey, D baby. Hey, public friendly number 1, number uno. Not the hashtag I'll stay with Tay. Period. Y'all make me so happy when I see that. Child, y'all know how your girl been getting. Child, it's been a mess. Y'all hear me? Cause your girl. Let me see here. I gotta Britain sent me some new stuff. So I gotta get my stuff in here. Period. Let me put that in there. Oops, let me take that off. See if that can go in there. Okay, way too big, they said. Excuse me, then, Mo. Let me see here. It ain't that big. Okay, I got a couple. Let's see if that go in. No. Okay, let me take them off. Wait, my computer might be froze. Okay. Oh, I want to put one in there at a time. Okay, let me do this one. In a couple seconds. Oh, they don't even let me put that one in. Oh, buns, I'll just share them. I'll share them. Oops, not that. Yeah, but what y'all been up to? Did I finish going down the list? Let me go down the list. Hey, Miss Virgo. Hey, Miss Mace. How you been? And let me see here. I got to mostly everybody up in the chat. Hey, Miss Pris. Not y'all speaking of cookie, child. Hey, Miss Angela Jean is not my lover. Woo! Hey, KBI. Child. Thank y'all for the alerts as well. Shit. It's a damn mess. Hey, Miss Playtime. Hey, Mocha Pam. Hey, JS. Not just saying, period. Hey, Miss Cheryl. Thank you, Miss Rainbow Sun. Thank y'all. Thank y'all. Y'all keep my eyes together. Don't y'all start. Don't y'all start. Hey, Miss Mary Jackson. Hey, Miss Warm Chocolate. Hey, nice to see me. Hey, Sweet Pea, how you been? Hey, oh, that's nice to see me. I said it already. Hey, y'all. Well, hey again. Hey, Charlie J. Let me go on down here. Sweet ass is not you being the first in the Bill Nye East. Hey, Missy in Kentucky. Yeah, y'all tell my favorite damn girl, happy birthday, Miss Mary. Her birthday tomorrow, y'all. But y'all know I probably ain't gonna be live tomorrow, so we gotta get it out now. WhenTakeTalk@gmail.com is Mary. Hey, Miss Darlene Games. Hey, Christy. Hey, Regina. Hey, Shawnee. Okay, I think I'm at the end. Hey, Miss Kim Irons, how you doing? And y'all know what? I really went live. I wanted to go live yesterday because I had this information yesterday. But thank you, Miss Gladys, for the $25 cash app. Hashtag I stand with Tay. And that's on period. That's on period. I'm about to give her the money song. Period.
Check. All I really want to see is us. I don't really need a D, I need us. All a bad bitch need is us.
Okay, period. Okay. Cause child, you go out. Hey guys, welcome back to my channel. It's the wrong one. How I get that one on here? They let that whole thing play on here? 1 second. Y'all remember this?
Caught up in a real lie. Fatal attraction. Caught up in a real lie. Fatal attraction.
Y'all remember that? Child. I had to see my damn phone number on the bathroom stall. Is my picture and references about me and how fine I am and how good that is on a bathroom stall somewhere? Let me find out your daddy out here putting my information on the bathroom stall. Child, this cat's after me. Y'all know I am. Hey, Terry T, baby. Let's get into this. Okay. Hey, Miss Be Good. because I've been watching this damn docket, and the judge haven't ruled on Anonymous's thing, her request to dismiss herself and checkmate them. Like, what the fuck? For one, what they got to do with you? But let's just pull up the documentation so we can see what this heifer been up to. Because insta checkmate them, they also has entered the GD building. So let me pull a documentation up. Baby, I'm talking crazy. Oh, let me show the screen. So here we have the case number here with the plaintiff, Maurice J. Scott Sr. Okay, plaintiff, Maurice J. Scott Sr. versus Sarita L. McNeil et al. Defendants. Okay, all defendants were listed on the previous documentation. Okay, and here we have a motion to dismiss. Pursuant to Rule 12b-6 of Alabama Rules of Civil Procedure, defendant Instant Checkmate LLC, Intellis LLC, and Truefinder LLC, Movents, move to dismiss plaintiff's second amended complaint. Each of plaintiff's claims failed to state a claim upon which relief can be granted. Look like somebody else just had a recent dismissal. Hey, Mickey Thicky just had a recent dismissal for failure to state a claim. The judge gave them 2 times. They could have amended the complaint. They did try that and it failed. The judge dismissed it and said, please get the fuck out of my face. So yeah. So they're filing this as, failure to state a claim upon which relief can be granted because plaintiff cannot support his claims against defendants under Alabama law. In further support of their motion, Movin submit their memorandum of law filed simultaneously with and submitted respectfully March 3rd. So let me go to that document. Here we go. As a couple of things, and then here is their said brief. Now, here we go. Memorandum of law in support of motion to dismiss. Pursuant to Rule 12b-6 of Alabama Rules of Civil Procedure, defendants instant checkmate. Y'all know all of them. We're going to just call them the Movins. Submit this memorandum of law in support of their motion to dismiss. This is a motion, plaintiff's second amended complaint. Okay. This is the introduction. We're not going to read all of it. We just going to whine on through a little bit and breeze through the important parts. I'm sorry, I didn't know I wasn't sharing. Okay, we're going to breeze through the important parts. And let me see here. Thank you so much, Miss Bridget J914 for the $10 super chat. For document dues, period. Thank you. We on the documentation. Pulling up documentation on our screen so everybody can view the documentation. Okay? View the documentation that's completed. Nothing is cut off. Y'all see this? Look at this full documentation. Y'all ever seen some shit like this? Full documentation on a court document?
Check. All I really want to see is the. I don't really need a D, I need the. All a bad bitch need is the.
Yeah, so it looks like these attorneys here in Alabama, they are genius. They have the documents. We can read the full thing. Let me see here. Thank you, Miss Bridget J. again. Hey, Marcella, speak with your ground. Marcella, why you ain't ask if we can see you? Let me block you and so you can ask. One moment, please. I'm just playing. Yes, Britt, nothing like seeing the documentation for self. Here we go. Plaintiff asserts claims for defamation and false light invasion of privacy against Movens, and he gives the complaint numbers. Movens are companies that provide on-demand online background reports compiled from publicly available records. Plaintiffs' claims against Movens are based solely on allegations that defendants Black Titanic, Sarita L. McNeil, and Here for Hot Tea acquired a copy of a report or reports provided by Movens that falsely attributed criminal conduct to plaintiffs, and then those of other persons repeated those statements in various YouTube videos. They like, how the fuck we get into shit? We ain't tell them motherfuckers to go on there, read no bullshit or saying no bullshit that is not even you. More to come, Britt. The report at issue appears to be the one attached as Exhibit A to defendant McNeil's answer, document 29, and to her motion to dismiss, document 310. The report. While plaintiff has had the report since no later than February the 5th, 2024, when McNeil's answer was filed, he did not first assert claims against Movens until January 4th, 2026. Damn, 2 years later. Checkmate them said, how is you cool? How is you cool? How is you cool? The Movens said, what? I know you fucking lying. I know you fucking lying. All claims against Movens fail for numerous separate and independent reasons. Okay? I told y'all I felt like it was foolish for Maurice to even add them. Like, this was a damn reach. Why would you even add them on here? You already got the other ones with the dissemination of defamation, which it seems like that's what they're accustomed to doing. Accustomed to doing, filing defaming people's characters and accusing them of committing crimes and such. Yeah. That whole group, that crew, that's what they do. Okay. Y'all like my nails? I just did them yesterday. These are some chrome press-ons. Y'all like them? Period. Okay. The report is, one second. Okay. First, I thought they was in first of all. First, all claims fail because plaintiff fails to plausibly allege that Movens published a false statement of fact about him. In fact, the report referenced in and central to the complaint affirmatively disproves plaintiff allegations against Movens. The report is identified as the source of the alleged false assertions, but does not include any of the criminal records that plaintiff alleged gave rise to his claim. Further, the criminal records included in the report are of a person with a different name. See, that's why I said, Mo, what the hell your lemon head ass is doing? Why are you adding these people to this shit? Again, I still hold firm in my opinion that they was all in this shit together. Now he added them to try to get another corporation in this shit to get some money because they know all amongst each other. They ain't got no damn money. Why you think they was trying so hard? 5 amended complaints and Supreme Court dismissals for OWN. Because OWN got that money, that cho, okay? That dineros. They wanted that. They already know amongst each other, they ain't got nothing but debt. Okay, let's move on. So they said further, the criminal records included in the report are of a person with a different name, different damn date of birth, and the report excessively disclaims the records may not be 100% accurate or complete and belong to the report subject. If other defendants misinterpreted those or other records to make separate defamatory statements against plaintiff, claims may lie against them hoes, not us. Hey, Miss Jean Jazzy J. The Movement said, go after them hoes like you been doing, because we ain't got nothing for you. Get somebody else to do it. But the complaint does not allege any false assertions by Movens. Like they said, motherfucker, they submitted shit that don't even got nothing to do with you. That's not even your name. Second, all claims against Movens are separately failed because plaintiff has not alleged that Movens acted with the requisite intent. For his defamation claims, plaintiff's own allegations establish that he is a public figure. Well, that's an allegation. Allegedly. It's like, no. Thus requiring plaintiff to allege that Movens acted with actual malice. His false light claims likewise require that plaintiff allege that Movens acted with knowledge or reckless disregard to falsity. Plaintiff, however, fails to allege this required intent, and once again, the report itself directly belies any such assertions. Like, what the fuck? Third, plaintiff's false light claim must be dismissed because plaintiff fails to allege the publicity, I guess, I don't know that word, element, which requires plaintiffs allege that Movens communicated false assertions to the public at large or to so many persons that the matter must be regarded as substantially certain to become one of public knowledge. And they give a case study, cleaned up. Here, plaintiff alleges Movens only gave the report to 3 other individuals. He didn't even say it gave it to 3 other individuals. Just one disgraced attorney. Y'all remember the one that got the license stripped from the damn wall and had to return it to the Office of Chief Disciplinary Counsel in Missouri? That bitch? Yeah, her. Rick James Esquire no more. That one. Let me see if I got any photos for this person. Y'all remember this one right here? Hey, Miss Stephanie. This one right here. Oh, y'all remember? Okay. I'm just checking them to see if y'all remember old Bookman, Esquire. Old Buffalo Bud Esquire. Finally, all the plaintiff's claims fail to allege any against Intellis LLC, the True Finder LLC. The report is identified as originating from InstaCheckmate LLC, and plaintiff identifies no report or alleged false statements by either Intellis LLC or True Finder. Let me see if I want to go to the arguments. I might have to read the arguments, y'all. We might have to read the arguments. Let's try to zip through them, because they kind of let off into Mole's ass, and I liked it. Okay. Rule 12B. This is the argument. Dismissal under Rule 12b-6 is warranted when it appears beyond doubt that the plaintiff can prove no set of facts in support of the claim that would entitle plaintiff to relief. This is going around like wildfire. Further, it is well settled that a plaintiff's complaint must plead a cognizable legal theory to defeat a motion to dismiss filed pursuant to Rule 12b-6. Alabama Rule 12b-6 is identical to its federal counterpart, as both rules provide that a party may assert by motion the defense of failure to state a claim against which relief may be granted. And thus, Alabama courts look to be federal courts' interpretation of the federal rules of civil procedure when those rules are similar to our own. Okay. While courts are required to accept all factual allegations in a complaint as true at the motion to dismiss stage, they are not required to accept conclusory allegations. Hey, Miss Deidre, y'all keep this right here in mind, okay? Conclusory allegations, meaning shit that you just came up with in your motherfucking head without any proof to back it up. Not an exhibit, not a police report, nothing as fact that this is you, this happened to you by said person. Conclusory allegations. And they give a case study. Emphasis in original. Finding conclusory allegations that a defendant acted willfully, maliciously, fraudulently, or in bad faith were insignificant to state a claim where the plaintiff failed to provide any factual basis to support them. Rather, to survive a motion to dismiss, the plaintiff is required to plead facts that would support those conclusory allegations, like the ones that he presented for Buffalo Butt Esquire No Longer, Black Titanic, and Here for the Hot Tea. He provided transcripts from their live streams with the links to the videos, thumbnails to the videos, and transcripts from the videos, as well as screenshots of Black Titanic's comment section, where she continued the defamation in there. Hello, Scorpion Miz. Hello, Scorpion Miz. Yes, hello, Scorpion Miz. I am so happy for you. But thank you for coming to the chat. Hey, Niecy. So, yes. So, when you start your lawsuit, when you do your lawsuit, remember how even with my lawsuit, my countersuit against Anonymous, I put exhibits in there showing where she had did certain things to me. Okay. Also, in the OCDC packet that I sent over, I put in there different things that she was doing. Hey, Mocha Pam. I think I already spoke to you, Mocha Pam, but if I didn't, hey, different things that she had been doing that was unethical. Like sending process service to my house without telling the court, put notice into the court that she was going to put on notice to the court that she was going to send a process server to my home, and then also not satisfying or putting the results for your last notice to serve the person before you put in notice that you're going to serve them again. So if people show up at your home if she haven't put any kind of notifications out or anything to the court, let the court know that she's going to send somebody to your home, then that there, dear, is harassment. That's unethical behavior. She's not a pro se litigant. Well, right now she regular old pro se, okay? A regular old lay person, okay? Back to Chicken George. When if Chicken George would have stayed in the county beyond them 60 days when he got his freedom papers, and remember that the guy told him, and okay, you stay 10 more days, you gonna be back to regular old N-word. That's what they use in the movie. I don't use it, okay? But yes, so now she back to being regular old layperson because the license has been suspended for all the unethical behavior that it seems like people like to uphold. They don't mention all of that stuff. Yeah. They're not even supposed to be saying that she's an attorney anymore because she's a disgraced attorney that's been suspended pending a judicial hearing with the Bar Association. Yeah. Y'all see that? Yeah. All right. So yeah, but for one exception, the only substantial facts material on a Rule 12b-6 motion to dismiss are the facts alleged in the complaint. And they give another case study. The exception is that if a plaintiff does not incorporate by reference or attach a document to his complaint, but the document is referred to in the complaint and is central to the plaintiff's claim, a defendant may submit an indisputable, authentic copy to the court to be considered on the motion to dismiss. Wait a minute. Wait a GD minute. I'm not no lawyer, y'all. This just when Tay talk old Esquire. Okay. But this kind of looks like Maurice. Are you listening, Onion Head? Because this kind of looks like they're low-key trying to put a bug in Maurice's ear. Refer to the complainants in central. A defendant may submit an indisputable, authentic copy to the court to be considered on a motion to dismiss. PBE, you. Okay, let me see if I'm correct. This means that they are willing to submit the authentic background report that they have for their database for Maurice. And I'm kind of getting a notion that it's saying that the background check that Bookman Esquire no longer submitted may not be what the fuck they even produced on their website. Marcella, I don't know if you still, kick it with the snots or whatnot, or whoever do, but you might want to tell Maurice that he might want to request an authentic copy from Checkmate now. Yeah, okay. Y'all think that's what it is? Because you, PBE, you said she did the same thing with yours. Anonymous, your fucking goose is cooked because she submitted the background check, okay? She submitted the background check. And I encourage anybody that's dealing with any of them in these cases, all of the people, y'all know the family. Y'all know the family. The ones that seem like they met at a mental institution for lesbians. Them bitches. if anybody is involved in any kind of court things with them, they might want to get these things authenticated. Tell the judge that whatever the fuck they submit, you might want to get them authenticated. Because I'm just saying, this look like this what they saying. Motion as a summary judgment motion by considering authenticated documents that are attached to the motion to dismiss if the documents are referred to in the complaint and are central to the plaintiff's claim. Cleanup. What is that cleanup? PBE, ask Chat GPT why this thing keeps saying cleanup. Let me see. What's the day? I'm about to send this to you real quick, PBE. See if maybe if you can get us in Chat GPT and see what this means. Okay, see if you can PB, I sent it to you. I just sent it to you. Hold on. Okay, yeah. So that's what I was saying, that it looks like they're trying to get for Maurice to get this authenticated, get those documents that they got authenticated that she submitted, because they said that she submitted a background check that's claimingly supposed to be from them, from Checkmate. And they saying basically that shit ain't authentic. Ooh. And I wonder what this cleanup mean. Why I keep saying cleanup. All the plaintiff's claims against Movens fail because plaintiff cannot establish Movens published a falsity about him. A common element of all claims against Movens is publication of a false statement. And you, right, they didn't. They didn't publish this shit. The ones that you sued originally, that's who published it. Y'all couldn't get nobody else to go along with the bullshit, okay? The problem, dismissing element of false light and defamation to require publication of a falsity. Okay, that is right. The problem for a plaintiff is that the report does not contain the alleged false statements that form the basis of his defamation or false light claims. Exhibit A is a report referenced in the complaint. The Movens do not dispute that it is the report of which plaintiff relies, the court may consider Exhibit A in resolving this Rule 12b-6 motion because the report is expressly referenced in and central to the complaint. Referring to the January 4th, 2024 report obtained by McNeil. Yeah, they saying this shit where she submitted back in 2004, that complaint, he might want to get that authenticated. Plaintiff alleges that based at least in part on this report, defendant McNeil claimed he had an extensive record in Baltimore, was known as a street pharmacist, was on probation, and was sentenced to 120 months for drugs. However, nothing in Exhibit A reflects any drug conviction, any felony sentence, any 10-year term of imprisonment, any narcotics-related probation, or even any presence in Baltimore. See Exhibit A. The report contains no reference to drug trafficking, drug distribution, or any controlled substance offense. The document central to plaintiff's claim against Movin simply does not contain the false statements he alleges in his complaint. So, her even submitting those background reports, for one, does not show that Maurice J. Scott had any of that. But these are things that they discussed. He provided the transcripts that they discussed these things on Black Titanic's panel. And Here for Hot Salamander also reported on it, calling him all type of hoes. Y'all know how she like to do. Okay, so they said none of that shit was even in the background report that she submitted. So they don't know why the fuck she was saying that shit. So while you trying to sue them for presenting false information out so people could pull it up, they said that shit wasn't even on the report she said she pulled. Equally important, the report does not contain any allegedly false statements about plaintiff. The report does not purport to attribute any criminal record to Maurice Jefferson Scott. The first 2 pages identify the subject of the report as Maurice Jefferson Scott, born September 1978. Exhibit A at 1-2. Beginning on the 3rd page, however, the section titled Likely Criminal or Traffic Records identifies a different individual, Maurice Rasheen Scott, born February 1979. The only record in Exhibit A that is actually attributed to Maurice J. Scott, born September 1978, appear under the separate heading, Less Likely Criminal or Traffic Records, and reflects an unspecified traffic matter. The report, therefore, does not attribute any criminal history to Maurice Jefferson Scott, who's what we talking about, because he's a named defendant. He has a legal name that he put on the court papers when he pursued this lawsuit. When he pursued the lawsuit, he put a legal name on there so the judge could know who the fuck to address, email, all of the things that is related to Maurice Jefferson Scott. So the judge say, dismiss, get your ragged ass out my damn face, it's going to go to Maurice Jefferson Scott at his address in Madison County. Hey, T from TV. Child. Hey, Miss Sandrine. Did I miss anybody? A peanut butter face in here. Caramel Real in here. Hey, Miss Caramel Real. Hey, Miss Press. I ain't see y'all. Y'all done skated past me, child. I'm reading the documentation, getting up into it. Getting up into it. So, yeah. So, they saying none of that shit is even for Maurice. Further underscoring that the report does not attribute any criminal records to plaintiff that gives rise to his claims is a prominent disclaimer directly above the criminal records under the heading Criminal and Traffic Records. The report expressly states, The criminal and traffic record information contained in our report may not be 100% accurate or complete. This is because the information is pulled from records maintained by government agencies, and the information included in those records may not be 100% accurate or complete. Please use this information as a starting point for your own due diligence and investigation. Please be advised that records matching your aliases may also be included. Now, where they get Maurice Regine Scott from, they just made that shit up. In my humble opinion, they just made this bullshit up. Because, I mean, I see if they had pulled one for Maurice James Scott. At least it started with a J. This shit right here is full of it. They full of shit. This is baloney. Okay? Exhibit A at 3, because Movens expressly disclosed that the information may not be 100% accurate or complete and is instead a starting point for your own due diligence and investigation. Plaintiff further cannot plausibly allege that the subject criminal records of someone with a different name and date of birth were attributed to him. Oh, yes. But also, too, Maurice in the Missouri case, in that case, she continuously put your name as Maurice Jefferson Scott, aka Maurice Regine Scott. So she's attributing you to that other person that doesn't even have the same birthday as you. Right, Ms. Mary. They just dig in the hole, just dig deeper. She's going to be in quite the pickle. I'm still curious as to why the hell Maurice has not filed any complaints with her with the OCDC. Because the complaint does not attribute the false facts to the statements of facts to Movens, all claims against Movens should be dismissed. Okay, I got it. Thank you, PBE. Alternatively, all plaintiffs' claims against Movens fail because he fails to allege that Movens published any statements with the requisite intent. To establish his false light claim against Movens, plaintiff must also allege that Movens had knowledge of or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the other would be placed. He can't prove that because they didn't, for one, they don't know him. They don't give a damn about his ass. Hey, Ed Anonymous. And when we talking shit about the Anonymous, we talking shit about Anonymous, as in Bookman Esquire no more, Rick James Esquire no more. So I don't know if you heard or not, but if you are, we talking about your ass, okay? Because plaintiff is a public figure, his defamation claims require a similar intent. Plaintiff describes himself as a public figure, i.e. as an original cast member of the reality television show Love and Marriage Huntsville since it premiered in January 2018, who has also gained popularity based on his appearance on the reality show, social media presence, familial and professional life, and charitable work he does. What charitable work? Mom, cut the shit. Alleging the reality show has gained significant popularity and routinely ranks in the top 50 cable television shows on Saturday on which it airs. This heightens plaintiff's pleading burden. Ooh. Because at the heart of the First Amendment is the recognition of the fundamental importance of the free flow of ideas and opinions on matters of public intent and concern. When applying state defamation law to public figures, the First Amendment opposes additional limitations. And they give some quotes, court references. Accordingly, plaintiff must allege facts to support that the alleged false statements by Movens were made with actual malice. He can't do that with them because they didn't publish the facts. Whatever they did publish, the one, not even him, and the one that they published that was about him does not contain any defamatory statements that not even a fucking traffic ticket. Hey, cousin. Thank you for the $4.99 super chat. Taritha, what up, though? What up? What up, though? Hey, cousin, Bailey, Cookie, Mine, Tater. You got a whole list now. Not you to added Bailey up in the mall. Y'all see that short with Bailey on there? At our little brunch last week. Let me take a brief little intermission to show y'all my baby real quick, okay? Because she a mess. She's a mess. Let me find her. Uno momento. Shorts. Let me see here. I ain't gonna play the music because there's music on there, so I ain't gonna play the music. But look at her little butt. Look at her doing her little lips. And then Toddy was messing with her with that bottle. Look how she watched it like a hawk. She'll be here tomorrow. I might pop on to show y'all her tomorrow. She a little mess. Let me get back to the documentation of it all. Ciao. Because at the heart of the First Amendment is the recognition of the fundamental importance of free flows, interests, and concerns. Did I read this already? When applying defamation. Okay, he has to show actual malice. Actual malice requires that the statement be made with knowledge that it was false or with reckless disregard of whether it was false or not. So this right here shows that he can prove this with them because, for one, what she submitted as her evidence shows that the person that she was referencing is not even him. She's an attorney, for one. So, well, she was at that time. You know what? Was she on probation? Yeah, she was on probation then. But still not following the damn rules. But an attorney back then, no less, where she is supposed to do her due diligence before she say these type of things against somebody. She knew that he had just gotten to being a lawyer. So with that being said, you being a lawyer, you know good and fucking well he couldn't be no lawyer with all of those criminal charges that y'all was saying he had in his background. And then again, to say that he had recently had his record expunged in her new dismissal, talking about he had his record expunged. If he had the record expunged, you wouldn't have been able to pull the shit the fuck up. So how would you have known that he had it expunged? That again also implies that you knew that he had a criminal record and then he had it expunged. Karen Humphrey still MIA. Don't know where she at. Okay. No law degree for her yet either. And again, it's strange how the only Karen Humphreys that we can find with a law bar number was in Michigan. Right on over around Chion, then Dearborn, Michigan. Closer to Detroit, but close to Pontiac as well. About 40 minutes away. It's closer to Dito. Yep. However, let's move forward. According plaintiff must allege facts to support that the alleged false statements by Movens were made with actual malice. I read that part. Or the false with knowledge it was false. Okay, reckless. Finding plaintiffs their threadbare rectical that defendants acted with actual knowledge or reckless disregard did nothing to aid in satisfying his pleading burden. The core of this inquiry, is whether the speaker made a false publication with a high degree of awareness of probable falsity, and they did. In my opinion, the test does not ask what a reasonable, prudent man would have published, because they give a case study, but rather asks what the publisher in the instant case actually knew. Okay. So again, even the stuff that they put about Maurice and stuff like that in these court papers, is fictitious litigation. I don't know why he ain't seek to send shit for that shit. All this stuff about they had a plot with On and Maurice had a plot to lure Black Titanic out of her safe space so one of the other cast members can unalive her. Like, it's a mess. Oh, Miss Mary, my Gmail is WenteTalk@gmail.com. Let me put it in the chat for you. Thank you, Britt. That's for Miss Mary, not for y'all hyenas. Let me quit. Increase profits. Okay, the fact that the defendants published the defamatory material in order to increase its profits does not suffice to prove actual malice. He can prove them again. He can prove with their commentary and stuff like that and what they were saying. They can show malice. Even how they talked about him before and after the defamation. So he can prove malice. But in Alabama, I don't think he even have to prove that. Let me look. Alabama, I think we had looked this up before. Okay, Miss Mary. I think we looked this up before, and it didn't have that many things that they had to do. So let me see. It was a little bit more relaxed than other states, because other states, they be wanting you to prove a lot of shit for defamation, but I didn't think Alabama had it as that bad. To prove defamation in Alabama, you must establish that a false defamatory statement was made, published to a third party. Okay, so a false defamatory statement was made. That's check. Published to a third party. Check. On the YouTube channels and out to other people. And resulted in injury to your reputation. Clearly check, because after Black Titanic and Anonymous was talking about it on her channel, Black Titanic proceeded to give defamatory stuff in her comment section, where she was saying that Maurice snitched on her best friend that was, I guess, the head of the organization, and Maurice got everybody locked up. So she was saying basically that her accusing him of being a rug dealer. And that, you know, he was working with other kingpins, which one of them was her best friend. Okay. And that Maurice snitched on everybody and got everybody locked up. Wait, Miss Gladys, you got me another cash app? Oh, thank you so much, Miss Gladys, for the documents. Here we go. Oh, yes, here we go with the bull. Here we go with the bull. All right. Thank you so much. Let me get you the money song. I gave you the money song earlier, but it looked like you back with more money. Okay, let me give you some more money song. Okay, now song P. Play with your money.
Check money. All I really wanna see is the. I don't really need a D, I need the. All a bad bitch need is the.
All the bitch need is the money. Okay, so he has those checked. So, and then here for the hot salamander repeated the stuff, which caused harm to his reputation. Because people were saying that he was a rug dealer. And he's an attorney. The statement must be factual, not just an opinion. They stated it as fact. When Black Titanic added into the comment section that he snitched on her best friend and got all them locked up, she was stating it as a fact. It wasn't no opinion. It wasn't alleged. She was stating it as a fact, because that would mean that you know this personally because your friend was involved in it. Yeah. So, and made with at least negligence regarding its truthfulness, generally within 2 years statute of limitation. He kind of missed that with the checkmate people, but he had already filed a complaint, so I don't know what they don't do because he amended it. And it's funny again that anonymous Rick James bitch Esquire no longer even submitted the dismissal because of his amended complaint when she just did the same motherfucking thing last year. So yeah, key elements to prove defamation in Alabama include false and defamatory statement. The statement must be demonstrably false and harmful to your reputation. Publication, the statement must have been communicated either in writing, libel, or orally, which is slander, to a person or entity other than you. And he has both of these for Black Titanic because it was written in her comment section, and also orally, which is slander, on the channel. Okay. The defendant must have acted with negligence, not caring if it was true. They didn't give a fuck. Or because if you coming on YouTube and you putting stuff out, like I said, you at court documents and stuff like that, you put the court documents on the screen for people to read them. You can redact names and stuff like that that's not already known to people to protect people's privacy. But if it's a name that's already public that everybody already knows, then it's fine. But if it's a name that of somebody that's not known publicly, you can redact the names and stuff like that and publish the document so people can see the actual document. So let's say if they come and try to say I'm defaming their character by presenting the stuff right here, I have the court documents. This is in court documents. I'm reading this stuff from court documents and giving my opinion on the situation and what's being presented. If I think this shit is some bullshit, I'm going to call it as such. Okay. That's something that I will do. My due diligence is doing. If they come in here with some bullshit that's fake and fugazi looking, I'm going to question it. And I'm going to say, hey, this shit right here looks like it came from a motherfucker that just was born yesterday. Okay. Yesterday. Fault. The defendant must have have acted with negligence, not caring if it's true, or cases involving public figures, actual malice, knowing it was false, or acting with reckless disregard for the truth. In my opinion, he has that. He has that. All three of those ladies, well, only one is confirmed to be a lady. All three of those people that slandered his name, okay, like we could have just kept it, or they could have just kept it with the show, or how a piece of shit person we thought he was on the show and all that type of shit, or currently is, in my opinion. But I digress. But to bring up these type of things when he had just obtained his law degree, which means that this right here could have people, and plus by him being a public figure and you accusing him of being a rug dealer and all of a kingpin and having all these charges, 25 or some charges, all these charges in all of these different states and all of this stuff, and that's not even his name. Like that's content creating 101. It ain't no alleged, in my opinion. Allegedly his motherfucking name ain't Maurice Rasheen Scott. And if you report on some shit, you're blatantly disregarding that his name, as known as a public figure, is Maurice Jefferson Scott Sr. Because even on those court documents, when they first filed the countersuit and added on in there, they had him down there as Maurice Jefferson Scott Jr. And they had to fucking change it. They amended it to change it to Senior. Because Maurice Jefferson Scott Jr. was Lil Monster. I'm just saying, just because I don't like Maurice does not mean that they did not defame his fucking character and was malicious with this shit. A reckless disregard for the truth. Either they knew it was false, like Anonymous even repeating that shit. You knew it was false because you knew the Rasheen wasn't him, and you ain't never heard nobody call him Rasheen. Maurice Rasheen Scott. Where did you pick that up from? And if Black Titanic was even acting like he got her best friend locked up, that means you must not have some type of familiarity with him to be putting this stuff out here. So you knew that shit wasn't true. You knew Maurice Jefferson Scott didn't get your best friend locked up for rug distribution, being a kingpin. Identification. The statement must be of and concerning you. And they put his name up there. He was on the thumbnail and all that shit. Okay. Damages. You must prove that the statement caused actual damage to your reputation, or in some cases, the statement was defamatory per se, falsely accusing someone of a crime. Y'all ever heard of this before? The damages, you must prove that the statement caused actual damage to your reputation. Or in some cases, that the statement was defamatory per se. An example of a defamatory per se is falsely accusing someone of a crime. Falsely accusing someone of a crime. Let me make this big so y'all can see that part. Y'all see that part right there? Y'all see that part right there? That part right there. Uh-huh. And what did they accuse him of also? Because I was just saying, putting that information out there. Okay? When people falsely accuse people of crimes, that's defamation per se. What they said that he took their information or something when he actually subpoenaed, got an approval for a subpoena for Google, metadata, Instagram, all that shit, PayPal. So he didn't steal your information. He had early discovery motion requests. The judge approved the subpoena so that he could subpoena Google. Because, like, my name is Talkkkk on YouTube, but if they got to subpoena Google for my identity, let's say if I wasn't already doxxed out here in the world, and I had and I, you guys only knew me as Talkkkk. If they subpoena Google, they want to sue me, so they will subpoena Google to get my identification. And the judge approve it and do the order. Google got to give them the information that's on that payment slip, that AdSense, that Google AdSense information. Because when they cut them checks on the 21st of the month, it has to have your name on that batch. It got to have Natavia Garner. Because Natavia Garner got an account that got Natavia Garner on it. Ain't got no fucking Talkkkk. You can have Talkkkk LLC all you want, but when that payment come, Google gotta have your name, legal name, to release payments and shit like that too. Even on these back accounts, even if you don't even get Google AdSense, Google still have names and shit like that, IP addresses of the people that own these IP addresses, where they're at, address, all that shit. When you on this good old internet. Okay? It's very simple. It's clear. Y'all know that. But nevertheless, he was defamed. Okay? Let's get back to the document here. Further, plaintiff's conclusory allegation that defendants knowingly or recklessly made false statements without distinguishing amongst the individual defendants is insufficient, like somebody's funds, to survive a motion to dismiss. Conclusory allegations, unwarranted deductions of facts or legal conclusions masquerading as facts will not prevent dismissal. Holding that claim asserted collectively against all defendants are insufficient to state a claim against particular defendants where no specific allegations were directed to them. In Exhibit Parte Gillian, I guess it's a Supreme Court case, Alabama disregarded similar conclusory allegations that a defendant acted willfully, maliciously, fraudulently, or in bad faith because they were unsupported by any factual allegations. Moreover, the report itself directly negates any attempt to allege that movements knew that the specific criminal records in the report were false. Notably, the report included a robust disclaimer immediately above the display of the criminal record. And this is what they again show that they said is not 100% accurate. This just your little stepping stone to see what you're going to do with the mofo. You still need to try to pay somebody to get the real shit. And when you looking up the person, make sure it's the right person. Because what y'all have for Maurice Jefferson Scott didn't have all that shit in there. Plaintiffs' own allegations separately defeat false light claims against Movens. We ain't gonna go through that. Let me go to statements and conclusion. We cannot say the publication statements to this private group would make those statements essentially public knowledge. In fact, as the King defendants point out, 1500 in the publication Jefferson County. Here, plaintiffs' own allegations confirm that Movens did not communicate the alleged report to the public at large or to so many persons that the matter must be regarded as substantially certain to become one of public knowledge. To the contrary, he alleges only the 3 defendants in this case acquired a copy of a report from the Movens, that those defendants may have subsequently disseminated the information more broadly does not save his claim. Like Flickinger, because the report was not distributed to the public at large, plaintiff cannot allege that Movens gave publicity to the matter, and plaintiff's false light claim against Movens must be dismissed. The report defeats any claim against Itellus and Truthfinder. Finally, plaintiff claims against Itellus and Truthfinder must be dismissed for an additional reason. The report is identified as originating from Insta Checkmate, and defendant identifies no report or alleged false statements by either Itellus LLC or Truthfinder. In the absence of any such allegations about them, plaintiff cannot state claims against them. Conclusion. And in conclusion, because plaintiff cannot establish the essential elements of his false light or defamation claims, the motion to dismiss should be granted and claims against Movens dismissed with prejudice. And they submitted this, Vincent Bowden submitted this on March 3rd. And we have another document, return service, motion. Maurice cuts into anonymous too. Let me pull that one up. Plaintiff's objection to defendant Sarita L. McNeil's notice of intent to serve subpoena on non-party Oprah Winfrey Network LLC comes now. Plaintiff Maurice J. Scott Sr. Scott, I don't know how you put that in there. Herein and pursuant to Rule 26 and 45 Alabama R Rules of Procedure, Civil Procedure, objects to the scope and documents requested in the proposed subpoena to non-party Oprah Winfrey. They won't let the fuck go of Oprah Winfrey Network. And this is another reason why I feel like she was writing this shit too, because she can't let that shit go that Oprah Winfrey Network was dismissed 5 motherfucking times and in the damn Supreme Court. Get the hell out of here, bitch. For the reasons set forth herein, the request should be denied. 1, on February 20th, 2026, the clerk of the court entered pro se defendant Sarita L. McNeil filed notice of intent to serve subpoena on Oprah Winfrey Network LLC. The proposed subpoena to Oprah Winfrey Network LLC requests access to the following documents. Provide any and all information or items which fall within the scope of the request. The term document means but not limited to any writings, whether paper or electronically stored, the original and any copy, regardless of original or location of any book, correspondence, pamphlet, periodical, letter, email, computer screens, computer disk or computer program, memoranda, telegram, report. Okay, all the things that means document. Okay, emphasis on a employment contract and addendums signed and dated for employment plaintiff Maurice J. Scott. Why she didn't put Rasheen Scott in here? Why she? Sorry, Glove, you a mess. Thank you for the $10 super chat. Ty said this to PBE as a retainer. Not her getting a retainer. PBE Esquire. You got money on the floor. Let me give you the money song, crazy.
Check. All I really wanna see is us. I don't really need a D, I need us. All a bad bitch need is us.
Okay, so she wanted his original employment contract and addendums. And y'all notice again, she didn't put Maurice Rasheen Scott in her request for the employment record. She only put Maurice J. Scott because that's what the fuck she know him by. And that's it. Annual income statements, W-2s, 1099s, issued for your employer, plaintiff Maurice Jefferson Scott for 2018, 19, 20, all the way up into 2025 tax years, which also why the fuck did she? I told y'all about this before. Why the fuck do you need that? Why do you need his employment contracts? To defend yourself against defamation. You're not asking the law firm that he with or the Alabama Bar Association. You asking OWN for his employment contracts when they already told your motherfucking ass that he don't work for OWN. So add those fucking emphasis. First of all, tax and income related information is protected by a qualified privilege. You old janky hoe. Trying to get somebody damn tax information again. Maurice, would you mind reporting this bitch to the OCDC? Because none of this is even relevant to this case. Hey, Miss Gail. And he gives a case. For tax returns to be discoverable, they must be highly relevant. The litigant seeking their disclosure must show a compelling need for them, and their disclosure must be clearly required in the interest of justice. And he gave another case study. Initially, defendant Sarita L. McNeil has not demonstrated a compelling reason for the disclosure of Scott's personal financial matters. Nothing is found in the allegations of the complaint could be interpreted to make Scott's personal income or property records an issue. And he gave another case study. To the contrary, Scott's complaint alleges reputational harm by defendant Sarita McNeil that relates to her statements that allege Scott was a criminal and practicing law without a license in 2023. Bitch. See the second amended complaint. Scott filed his complaint regarding the reputational harm caused by the defendants in this matter, and the allegations did not concern Scott's personal finances, property, contracts, or income. And the requested documents are wholly irrelevant to the subject matter of this litigation. Further, the broad rules of discovery should not be misapplied so as to allow fishing expeditions in discovery. Some thresholds showing of relevance must be made before parties are required to open wide the doors of discovery and produce a variety of information which does not reasonably bear upon the issue in this case. What the fuck does his income or his employment contract got to do with your fucking defamation? Because your defamation was about him not being a fucking lawyer. So why didn't you ask that to the law firm that he had? Or ask that he produce his motherfucking license? Or his damn certificate from the law school or whatever? He gave another case study. In the present matter, McNeil has not alleged or demonstrated a threshold of relevance. Moreover, defendant McNeil has not exhibited a reason for, much less a compelling reason for, the documents requested. Likewise, Scott's alleged claim made by McNeil's alleged defamatory statements in 2023 and documents requested from 2018 to 22 is unmistakably unrelated to any of the alleged claims, right? Like you don't even need that for one, and for the years that you request them, you don't need them for. The fuck you need that for? Alleged claims or defenses. Notably, McNeil hasn't preferred a nexus between the alleged claims and the requested information. She just requested it because she thinks she always want to try to look at somebody fucking paperwork and see how much they fucking making when your shit is insufficient. Your funds are insufficient, ma'am. Miss over $250,000 in bankruptcy. McNeil's document request resembles an impermissible fishing expedition into irrelevant matters that is designed to harass, oppress, and cause undue burden. Additionally, not at issue is Scott's relationship with OWN, financial or otherwise. The allegations of the complaint do not allege that and are not related to any contractual matter. Moreover, documents related to Scott's personal finances or contractual relationships with OWN, which falls outside of the scope of a defamatory action, defamation action for reputational damage, are in no way reasonably calculated to lead to the discovery of admissible evidence. And therefore, such request falls outside of the ambit of permissible discovery under Rule 26 Alabama Rule of Procedure, Civil Procedure. Therefore, for the previous mentioned reasons, the scope and documents requested in defendant McNeil's non-party subpoena to OWN are irrelevant to matters that concern or are related to Scott's alleged claims or McNeil's defenses. And Scott's objection are due to be sustained and an order entered in his favor bearing the requested discovery. Wherefore, the foregoing premises consider plaintiff Maurice J. Scott Sr. respectfully request that this honorable court sustain his objection to the proposed subpoena to OWN and enter an order barring the requested discovery. Plaintiff further respectfully requests an order that any proposed subpoena be limited to matters that are related to the party's alleged claims or defense in this matter. Batch. And that's on P. Okay? So the judge did respond. Plaintiff's motion. So the order to motion to quash subpoena, objection to defendant McNeil's notice of intent to serve a subpoena on non-party owned filed by Maurice J. Scott is hereby other. Defendant McNeil is given 10 business days to respond to plaintiff's objection to subpoena duce tectum. So he's giving her 10 days, business days, to present this, the reason, a response to his objection. And the response is not going to be much of shit because she don't have a reason why his income, why his contract with anybody is relevant to a defamation case. That part right there. So that's where we at. That was all that was submitted. That was the last document on the 5th, which I think was Thursday. And that's all that they have on here now. We don't have any updates for the Missouri case for the bar suspension. Let me just make sure I check it again. Let me check it again real quick just to make sure. Oh, and I wanted to show y'all something too that was on this case right here. Let me find it. Yeah, there's nothing new on this yet. Okay. I wanted y'all to see this document right here. Because this is what Dr. Brown submitted in the case here. In her, anonymous put in. Oh, let me share. I ain't share the tab. Anonymous. Let me go back. Oh, I didn't need that. I needed this. One second. I want to do the original case. The original one. 1 second. Okay. So let me show y'all this one. Oh, this is not it either. 1 second. Okay, this is the one. Okay, let me. Okay, so y'all see in 9:19 of this one. Let me see who's this is under. I think this is under the one for PBE, the background information. Respondent, which is anonymous, also testified she had a business with a Dr. Brown where they helped YouTube content creators who had issues with their channels being stricken. Respondent testifies Dr. Brown's family was deep in the FBI, CIA, and had connections with judges and lawyers. The alleged basis of respondent's federal lawsuit is that these content creators doxed respondent. And these are all the people that she claims doxed her. Respondent testified at her sworn statement that she was unsuccessful in getting VC's, which is PBE, YouTube channel removed because now what I have been informed, and the same thing happened to my business associate, Dr. Brown, is that whoever's with Google and YouTube, we're being targeted for a reason. Somebody with a lot of influence. So then Dr. Brown, remember Dr. Brown submitted documentation to have this stricken from the record. Dr. Brown now, okay? Just Dr. Brown, no first name, nothing. Just Dr. Brown. Okay? And then one second. Then here we get a letter to the OCDC from Dr. Brown. Still just Dr. Brown. No first name, nothing to identify who the fuck a Dr. Brown is, but we digress. It's Dr. Brown. Motion for leave to intervene and request for redaction / removal of name from court and disciplinary records. Now, how the fuck did Dr. Brown know that the disciplinary council had put Sarita's information, put her name in because Sarita mentioned her, Dr. Brown, in her hearing, in the preliminary hearing. Comes now Dr. Brown appearing pro se and respectfully moves this honorable court for an order pursuant to Rule 24A or alternatively Rule 24B of the Federal Rules of Civil Procedure. Now, mind you, Anonymous told the OCDC that Dr. Brown had close ties with the family members in the FBI and CIA. But the FBI or the CIA didn't tell this motherfucker that when you submit court documents or submitting information to the court, you're supposed to have your full legal name on this motherfucker. They ain't tell her all that. Anonymous didn't even tell her that as a lawyer at that time, waiting on suspension. She ain't even tell her that. But I digress. Missouri Rules of Civil Procedure granting Dr. Brown leave to intervene for the limited purpose of seeking redaction or removal of Moven's personal name. So now your personal name is Dr. Brown? So is doctor your first name? Because I thought that was a prefix. Doctor is your first name and Brown is your last name. So I guess that is unique to the records, because Dr. DR would be the first name and Brown would be the last name. Can anybody do a search on that name and see what we get, if we get any, pull up any information? We don't want to dox them or whatnot, but we do want to pull up some information. Okay. Granting Dr. Brown leave to intervene for the limited purpose of seeking redaction or removal of Movent's personal name and identifying information from the public court and or disciplinary records related to respondents Sarita L. McNeil in the above styled and numbered case. In support thereof, Movent states as follows: introduction and factual allegations. Movent, Dr. Brown, you're not a Movent, is a private individual who is not a party to this action, but whose personal name and identifying information appear within the public record related to the above captioned matter. Wait for it, Marcella. You know where I'm going with this here, huh? Because some people don't forget this, okay? But you know, oh, when Tay talk, when Tay remembers. Baby, this jazz, why they love me so much? Baby, this jazz, why they can't get enough? Let me chill on the pipes. I got some singing to do tonight. Office of Chief Disciplinary Counsel informant, which is the Office of Chief Disciplinary Counsel, herein filed their information and motion for interim suspension or in the alternative motion to revoke probation against Sarita LaShawn McNeil on September 24, 2025. In this matter, in said document, Movent's last name was identified in both the redacted and unredacted versions filed on September 24th, 2025. Y'all, we are dealing with some motherfuckers here that is not mentally well. On a serious note, on a very fucking serious note, we are dealing with people that are not mentally well. In what world would a real doctor submit some bullshit like this and say that they're identifying their fucking real name, their last name, when their last name is fucking Brown? Somebody pinch me to let me know this shit is real. Okay? The fuck? How is you cool? How is you cool? How is you cool? In said documents, okay, I read that one. Also, informants' information referenced the Movent with connections with federal intelligence, i.e. FBI and CIA, judges and lawyers, etc. Did they name the FBI? How many fucking FBI agents and CIA agents are there? How many judges and lawyers is it? What the fuck? I gotta laugh to keep from crying. again, we are dealing with people that are not mentally well. Movit seeks intervention pursuant to Federal Rule of Civil Procedure 24A and alternatively Rule 24B and all the other bullshit for specific and limited purposes of requesting redaction and removal of Movit's personal information from filings, disciplinary records, and other materials publicly accessible through this court's docket and or associated agencies' databases. No, ma'am. The motherfucker, that fat bitch shouldn't have said the shit. Well, she didn't say fucking much yet. But this seems like you're scared that she's going to actually give the full motherfucking information. Because since they pull up everybody motherfucking shit, best believe they know each other's shit. They ain't just anonymous with each other. And pull up everybody else shit. Because somebody made a good point in one of them comment sections where they said it's funny how people claiming that people doxing them, yet they know everybody's real information. They know everybody else's personal information. Has anybody ever thought about that? Because we call Marcella the doxing queen, but most of us ain't actually ever seen Marcella dox anybody. But they got all Marcella information. Huh. I digress. I guess that's just for people that, you know, was born with a little sense and wasn't born yesterday. Okay. And no offense to any babies that was born yesterday, because I'm quite sure you guys are even smarter than this. Okay. Movit's previously made a good faith effort to resolve this matter informally by contacting informant's counsel, Ms. Natalie Sprangler, via email on September 24th, 2025. And again but she knew when she was doing this hearing that this shit was recorded. So she threw that name out there for a reason, which again, she didn't throw the whole thing out there that nobody will fucking recognize but an idiot or herself, which is an idiot, but it's nothing identifying about you, Dr. Brown. I'm quite sure there's millions of Dr. Browns, unless doctor is actually your first name. As of the filing of this motion, Movit has not received confirmation that the requested correction action has been taken, necessitating that the filing of this formal motion per se. Bitch. And again, this is another person that, you know, is a doctor, has direct ties to judges, lawyers, CIA agents, and FBI agents, yet none of them told them that it's not legal for you to even submit this shit without your legal fucking name. Or why one of them couldn't put a bug in the OCDC ear like, look, can y'all remove this name? Because they know that shit was some bullshit, and they weren't even about to entertain this shit. That's even if you know the motherfuckers. It's given that the FBI, the CIA, and the motherfucking judges and lawyers that y'all motherfuckers know are defense lawyers. Judges making rulings on y'all dumbasses. And the FBI and CIA investigating y'all motherfuckers. That's what is given. But I digress. Courts have further recognized that intervention for the purpose of protecting privacy and reputation. What will be the harm to your reputation? To not know who Dr. Brown is, or to remove Dr. Brown from the record, may be appropriate when the Movit personal information publicly is disclosed without necessity. Argument: the inclusion of Movin's name within these public records serve no ongoing legal factual, or public interest and may result in unwarranted reputational harm, harassment, and privacy violations. Yeah, because we know only one person that first name, legal name is Doctor, and their last name is Brown. So this must signify that you're really not even a motherfucking doctor. That's just your first name. I figured it out that quick. Sorry. Redacting or removing Movin's identifying information is consistent with the court's authority. I can't read any more of this, but respectfully submitted at a P.O. box in Naperville, Illinois. And they actually signed this shit, Dr. Brown. You know what? I got something else to show y'all. I got one more thing I'm going to show y'all. Naperville, Illinois. Y'all give me a moment. Talk amongst yourselves. PBE. PBE, can you send me that that letter that Anonymous wrote for Aunt Ann? I think I got it. 1 second. Oh, that's not it. 1 second. Dang, that's not it either. PBE, can you send me that thing real quick? PBE, can you send me one sec? Distance away. Okay. Okay, so I won't have to look for it. Okay, I'll just wait for you to send it. Let me see what y'all saying in the comment section. Because y'all see Dr. Brown live in Illinois as well. So, okay. Let me see. Just wait to get that because they were living up that way. I used to love going drinking in Naperville while I was in college. Just Jewel, not your little drunk tail out here drunk. How close is Naperville to oh, we don't know. Okay, because we don't know the city. Okay. 10 minutes away from Aurora? Oh. Everyone, they are taking turns coming after us for entertainment to distract our time. All this is fraudulent. I'll be glad when they just will rest. Yeah. Y'all. That's real close to Chicago. Okay. Hello, Loki. Yes, child. You got to catch up. We on some stuff. But I seen you ask. I told y'all I'm gonna give my tater tots 10 on pump 10. Y'all gonna have to come to my gas station. We gonna have a ceremony probably soon because I don't know if I told y'all or not, but I told y'all they had like fixed up my little pump because they got an only specified pump that I work on, but they're gonna be dazzle it and plate it, gold plate my pump. Okay. Now I don't know if the gas just gonna be premium in there because they might put me on just the elite. Hey, I said that. Hey. Thank you. Y'all know what I mean. Thank y'all for the love. Thank y'all for the love and support. I need it because your girl.
In a real life, fatal attraction.
Oh, child. Okay. Okay, let me see. PBE juice in the jet. Hey, political junkie. Not you watching The Wire. I should go back and watch The Wire. I didn't watch The Wire from the beginning. I had started watching it like toward almost when they was getting ready to go, like a couple seasons before they was getting ready to go off. And I think I did start watching it back from the beginning, but I had stopped. I think I watched The Corner from the beginning. Those were good ass shows. I tried to get into Snowfall, and I know it then went off, but I couldn't get into Snowfall like that. I used to Power, I loved it. And I stopped watching Power books and stuff like that. But Didum said that BMF is really good, and that's based from here. And I still haven't watched that yet. Okay, I'm gonna get on it. I'm gonna get on it. How you doing? Yikes, I've never watched The Wire or The Sopranos. I never watched The Sopranos either, but they say that shit is good. I'm gonna be crying when it ends. You know what I watched from beginning to end after it had went off? Being Mary Jane. And that shit was good. It was so good. I am Mary Jane. Going through them. Be all over the damn place, okay? Thank you, Miss Deidre, for the $20 cash app. Not for the love, for the love. Hashtag I stand with Tay. Not trying to start a whole little movement. Thank y'all so much. Let me get her the money song because she deserves it.
Check. All I really wanna see is us. I don't really need a D, I need the. All a bad bitch need is us.
Sir, when go on? When is P Valley coming back on? Not you still out stuff in your face. Well, this almost your birthday, so it's for your birthday. So don't mind your business. Okay. Let me see. She pulled it up. Okay. Let me see here. Let me go back to the email. Okay, so this is to whom it may concern. My name is Sarita L. McNeil. I am a Missouri federal and state attorney. Please see attached my official response in support of Trina Thomas. Go up. Okay, this is the letter. Please note that I have never had personal dealings with Miss Trina Thomas. What? Somebody else put that in their lawsuit too. That they never had personal dealings with the person, but yet you know about a court case that you about to put, that you putting a whole fucking presentation together in defense of this person, but you don't have no personal dealings with them. But we digress. Sir will go off. Oh, y'all, let me tell y'all this shit. Oh, you know what? Let me show y'all this real quick. Really quick. Let me show y'all this real quick. Oh, here it goes. Y'all check this here out. Who that? Who that sir will go off? Not the Greg Vonville, my profile of it on. I had like one of his posts where he had like him, Nicole, and Carlton doing a little dance. You know how they be doing those little dance. And and I was like, I commented and was like, can she just please keep both of them? And and the next day he was all looking all up at your girl profile, child. I gotta go on there and see if he started following me or whatnot. But I digress. Y'all mind your business. Okay, that mother so damn fine. Carlton fine too, but I don't like Carlton legs. The way he kind of is he knock me? Sir Rook, I don't like Carlton's legs, the bottom part of them, but the top part, Carlton fine as but I don't know. I like Dr. Greg Vaughn for her. He that is a fine ass fucker. Okay. Well, let me read this letter here. Let me get y'all up into the sharing of the documentation so we can see this Dr. Brown shit. Okay. But we digress. Okay, so y'all see here that she wrote this letter. Okay, I was right here. I have never had personal dealings with Miss Trina Thomas, known as YouTube content creator Aunt Ann. However, Miss Trina Thomas has had professional dealings with my company. Greg Vaughn is a character. Well, he's not a character, but he plays like a character, Dr. Kyle, on Beyond the Gates. He played on other soap operas too. However, I read that part. She's had professional dealings with her company. Our partnership, two Midwest women social media appeal service. This long ass, she made this up, y'all. Through my business partner, Dr. LB. Can we see that? Can we see that? Through my business partner, Dr. LB. Our partnership has assisted over 125 content creators on pro platforms such as YouTube, Instagram, Facebook, and Patreon. All letters were non-legal in nature. That's because her damn license was suspended. This business aligns with the principles of pro bono service outlined in ABA Model Rule 5.5 and Missouri Supreme Court Rule 4-61, which permit lawyers to perform certain pro bono services. Now, business partner, LB, Dr. LB. I'm just reporting the news. Just reporting the news. Y'all see it. Britt, you ain't shit. Y'all, somebody is stalking me. Let me see here. They got my stuff ready. Let me see if I can send it to the because it was acting funny earlier. Why is it not finding my what is this thing? A MacBook? I'm gonna email it to myself. So through y'all investigations, y'all have found Dr. Brown. One moment, please. I just wanted to show y'all that documentation with the connections with the LBs of it all. Naperville, Illinois, Dr. Brown, then Dr. LB, that was her partner, and all of that type of things, okay? So, yeah. So, it looks like Dr. Brown has been found. Who would have known? Let's see here. Hmm. Hmm. So Dr. Brown owns these anti-colic bottles for babies. Hmm. And also, just to preview, it looks like they may have almost be done with my pump. Let's check it out. This gonna be my thumbnail. This is giving thumbnail, okay? So y'all see the pump of it all right here. It's looking good so far. It's looking good. Maybe when they connect the electronics and stuff on there to prevent anybody from hacking through anybody's stuff or anything like that, we're gonna be all set. So this looks like this might be up and running for St. Patrick's Day. Okay. I know y'all jelly. Don't be jelly. Did I get Miss Deidre the money song?
Check money. All I really wanna see is the. I don't really need a D, I need the. All a bad bitch need is the.
Okay. Period. Get on Brit Paulette, because y'all know Brit ain't got no damn sense. Y'all know Brit ain't got no damn sense. Sweet asses, you know I got you, okay? I'm about to, when I tell y'all when stay my ass indoors, I'm about to be like SpongeBob. Indoors. I ain't taking my ass no damn Caino, Nakadasino, the Nino, none of that. Okay, because that requires gas, and I'm not about to be with the shits. The gas station, they pay me enough to where they don't give me no discount. Okay, so I have other perks. So, but I got y'all covered. When my pump is ready, I'm gonna have a grand opening, I guess, grand viewing. And I just want to collect at least $100 from each person that want to come by just to look at the pump. You're not getting no free gas though. But I will pump for free, okay? And you gotta pay $100 if you want to look at my pump. It's gonna be $100. I'm gonna start a GoFundMe. Actually, I'm gonna start a GoFundMe, and whoever want to look at the pump, if you pay your donation $100 on the GoFundMe, you know what? I don't know, because they spend a lot on this. I'm gonna take it up to $2,000. $2,000. And you get to come and look at the pump for 10 seconds. Because it's pump 10, you can look at it for 10 seconds. Okay? So, whoever I see on the GoFundMe with their shit, I'll go ahead and set up their viewing. 2,000, 10 seconds, get in here. Okay? So look forward for the GoFundMe. I don't think, what should I ask? Name it. GoFundMe for gas? Oh, yeah. Okay. GoFundMe for gas. I already got the name of it. I'll come up with some verbiage, and we'll go from there. Yes. Oh, yes. We will go from there. Wait a minute. Let me see here. Oh, thank you, Key, for the $10 cash out. Hashtag I stand with Tay. Love me some Tay. Oh, thank y'all.
Check money. All I really wanna see is the. I don't really need a D, I need the. All a bad bitch need is the.
Thank y'all so much for all the love. This what we got going on. Make sure y'all watch that Anton Daniels video that I just dropped. I just dropped it. Let me put the link in the chat for y'all little moles. And Also, make sure y'all hit a like button and give my baby a comment because she's a little mess. She is a little mess. She'll be over here tomorrow. So we gonna see her, but I'm live. So let me get the link for y'all. Y'all watch this. Damn, Cookie, where the fire at? What? She got something to tell like damn urgently. Oh, you want to see that pump? Okay, that's all you had to say. You didn't have to come down here like it was a damn fire in the house. If you want to see the pump, you could have just asked me to see the picture. Excuse the hell out of me. Child. Get over there and mind your business. Cookie already trying to put her 2,000 on the phone to see the pump. Okay. All right. So happy early birthday to all Miss Mary. Miss Mary, don't forget to email me. And I love y'all. I'll see y'all soon. But I'm gonna be doing the pre-recorded videos for the Anton Daniel stuff because it's a whole bunch of bullshit going on. It's a whole bunch of stuff going on with that guy and this girl that I don't think a lot was going on together. But y'all will see what I think about it in the thing. And hey, T from TV again, thank you to all the content creators and my subbies for all of your support and everything. Thank you guys so much. I cannot express the appreciation. Y'all had me the other day over this mofo, eyes wet than a mo. Okay, so thank y'all, love y'all. Thank y'all for the super chats and cash apps. And we have something else here. Let me see here.